And today's on behalf of SIRC, I welcome you to the seminar on arbitration, sir. Before I introduce the speaker, let me describe his profile for a brief note for 1 minute. Veer Raghavan, Inbavijayan, BABL, he is a BABLB, FICA, FAIRDRA, FPIIRB, PAP, KFCRI, FCIRB UK, advocate, international arbitrator and mediator. He is also managing partner of Co Global LLP. Global examination. He is also a global examination board member, Chartered Institute of Arbitrator UK, regional pathway leader, course director, and fully approved tutor for CIAR UK, co-chairperson, Chartered Institute of Arbitrator South Indian chapter. He is also vice chairman, Society of Construction Law India, EC member of SIRC and chairman SIRC Arbitration Committee of India, advisor and course director of Bangladesh International Mediation Society, Bangladesh. He is also visiting professor for Tamil Nadu, Dr. Ambedkar Law University and Indian Maritime University, global advisory board member, Hyderabad Arbitration Center, India, professional development and educational committee member of ARDA, Malaysia. He is also a management committee and a global advisor, COWISE Foundation, Conflict Resolution International. He is also a member of Governing Council, member of Indian Council of Arbitration, ICAI. He is also a technical assistant and advisor for various AIDR institutions worldwide. Sir, Inbavijayan was educated at Dr. Ambedkar University Law College, University of Madras. On completion of his legal education, he took up litigation practice at High Court of Madras, 1997. His enthusiasm towards ADR made him to pursue whole-time arbitration practice since 2001. So far, he has presided as a sole arbitrator and represented as counsel in over 400 domestic cases, several small claims, commercial or financial arbitrations, and 16 international arbitrations. His area of practice includes international commercial arbitration, maritime arbitration, international trade and contracts, IPRs, construction disputes, finance and banking disputes, securities markets, JVs, LCs or ADRs, sale of goods, domain name and disputes, and investment disputes. He has been accredited as arbitrator in many areas, which I have already mentioned previously. To add up, he is a project advisor of an arbitration institute, KFCARI, and inducted as a member of ICCA. He had been listed in the 2008 edition of International Who was of Commercial Arbitrator, to add up as a chairman of Asia Directory. Sir, I have a long profile of you. With this small profile, I'm introducing you to our August gathering of members to give us a in-depth knowledge in arbitration process, since the arbitration nowadays is becoming a complicated, and we require you how we should simplify it at the best to our clients while we suggest them. So I request you to further process for your speech, sir. Thank you for giving us SIRC and a great opportunity to hear you, sir. Thank you.
Thank you. Thank you, Mr. Sunil Kumar. Good evening to one and all. First of all, I'll apologize for the reason behind from changing a physical meeting to a virtual meeting. Because of my health, I had to change it. And I have to thank the SIRC for making this arrangement in a short notice. Today, I'm going to share about the very interesting area, as the very important aspect of arbitration has to be dealt carefully. My topic, what has been given, is on the changes in the law. But before going into the changes into the law, I have to just narrate initially about some basic components of the arbitration and how it has been facilitated and what is the general procedural issues which arises in arbitration, particularly in India. Many would accept that the arbitration which was created much earlier, even before 1996, even before the globalization, we did have some legislations during the British period, wherein the 1940 Arbitration Act was facilitating the arbitration, and many of our cases were reasonably resolved by this particular act. Of late, the development in the economy and the changes, rapid changes happening in multiple fold, made a necessity that this law also has to be changed. Now, we have this wonderful arbitration legislation, which is the Arbitration Conciliation Act 1996, which most of you would have already been familiarized. Having said that, what is significance in arbitration? Why we are all rushing to arbitration, and how this arbitration has been constructively used in resolving the disputes, and recently, what are the impediments what we are facing in an arbitration process, particularly the outcome, how we are going to deal with the outcome of that particular process. Generally, why going to arbitration is very simple, that we obviously take the party's autonomy a prime role in an arbitration. The party has the right to decide upon multiple factors. The party can choose the judge, that is the arbitrator. The party has the right to fix the procedure. The party has the abundant choice given to when they are nominating the arbitral tribunal. These are some agreements what they can agree on. It is multiple, I think more than 20 aspects can be agreed, and the party's autonomy is safeguarded when it comes to arbitration. This is the reason why we always rush to arbitration. Along with that, we do have some other benefits or advantages, what we can say, why we are going to arbitration. The arbitration process is consuming a limited time, not like a judicial process. A reasonable time is being taken for the arbitration, and particularly the 1996 Act, even though it was not mentioning about a time frame for completing the arbitration, it was reasonably managing at least the mid-level and less complex disputes within a reasonable time. Of late, there are some large arbitrations like construction arbitration, maritime arbitrations, arbitrations relating to the business disputes, which also just started taking a longer time, sometimes even 4 years, 5 years to get completed. But overall, the advantage what we have in arbitration is less time consuming. In that way, it is also an advantageous position. And recent past, when I'm dealing with the amendments, what the law suggested in 2015 and 19, there are some time frame also given to deal with the arbitration, particularly completing the arbitration within 12 months or 12 plus 6, 18 months. Likewise, multiple provisions has been added, and those makes this particular system or mechanism even more strengthened, and we are getting the benefit out of it. Moving on to the next advantage, why we are going to arbitration, is about the cost. Many would not accept me initially. Cost, when it comes to cost, arbitration is generally considered to be expensive. It is not like that. Arbitration might be expensive, but still the process happening in the arbitration, it is a process which is equivalent to the trial process happening in the courts. And the trial process completes without having multiple layer of appeals. We don't have a multiple layer of appeals. In that way, the cost is considered to be reasonable in arbitration. These reasons for why to go to arbitration also has been facilitated by the important factor of enforcement. We are happy to deal with these disputes outside the court. No doubt we are not interested to take the matter to the normal judicial courts. We are taking the matter to a private arbitrator, and that arbitrator is going to give a judgment which is called the award. To what extent it can be enforced? Fortunately, we do have a legal sanctity for that particular outcome, and that outcome is considered to be equivalent to a decree passed by the courts. In that way, enforcement also is quite possible in arbitration, even though it is happening outside the court. Finally, most important, why we go to arbitration is all about privacy and confidentiality. Privacy. Most of us, particularly dealing with business disputes, won't be interested to make our actual disputes or litigations known to the public or even to a competitor or even to a third party. In that aspect, when it comes to arbitration, it is considered to be private and it is also considered to be confidential. And the law also facilitate the recent amendments gives a strength to it so that we do successfully complete this arbitration in a private manner as well as in a confidential aspect. All these, whether it is going to be party autonomy, whether it is going to be less time consuming, whether it is going to be the cost effective, or whether it is going to be enforcement, and finally, whether it is going to be private and confidentiality, all these combinedly make us facilitated to go to arbitration. This is the spirit of arbitration that, keeping in mind, we'll move on to the next level. This spirit of arbitration is now being challenged. As the introducer was very happy to put about the present day situation of how to handle the arbitration procedure, we are now having a multiple challenge on this process, whether it is going to be dealing in the courts or whether it is likely to be dealt in the arbitration process or whether it is going to be post-arbitration process to the courts while enforcement of challenge. Multiple aspects has been now combined together and making reasonable pressure for this wonderful process. Still, this pressure, what has been put forward when it comes to the procedural aspects in arbitration, we do have some reasonable the changes which has happened in the law. Now, I will just move on to the law, which I wanted to highlight initially, and then later I'll just touch upon the other aspects of arbitration, particularly the procedure. Okay, this is a slight overview of the present development in arbitration law. As I earlier mentioned, this law, which is recently passed in the year 1996, out of the globalization or whatever the global changes has happened based on the economic aspects, this particular aspect of the law 1996 is a harmonized law. It is not that we are alone having this particular law. A similar conceptual law is also in practice and also implemented in more than 100 countries. That is a very important thing. Why we are going to arbitration? Also add one more aspect that now the global, sorry, the globalized system is reasonably facilitated by the dispute resolution process also, and arbitration is very important tool to deal with such disputes in a constructive way, not only in India, outside India also. Why? Because a harmonized legal system is available in multiple jurisdictions, particularly the developed jurisdiction. In that way, we need not worry about where we are going to arbitrate. We can arbitrate in any location, any venue, any place, any country, any seat, depending upon the nationality of the arbitration. That doesn't mean that if there are two Indian parties trying to resolve their dispute in the contract, go for a seat or a place outside the country. There is no restriction, but still the feasibility is better going with an Indian seat or an Indian place of arbitration. But overall, this globalized scenario has changed because of this harmonization of the legal system, particularly on the arbitration front. Coming to this presentation, what I have just shared with all of you, it is an interesting point that still we call this particular law to be a recently enacted law. 1996, now we are in 2022, but this law is evolving. This law has now seen the amendments, particularly in the year 2015, 2019, and 2021. These developments are very important, and these developments, particularly in the law, is helping the parties to overcome, not only the parties, the stakeholders, whether it's a consultant or the arbitrator or any other third person who are quite comfortable with this process, are also utilizing these amendments in a constructive way. These developments in 15, 19, and 21 to a reasonable level has answered all the anomalies which has been arisen in the 1996 Principal Act by way of implementation or by way of execution of these arbitral process. Looking into the first aspect, that is the 2015 amendment. In 2015, what happened? Very interestingly, when you happen to see the actual definition of the codes, it is a common word which is used in the 1996 Act, that a principal civil code in a district and also includes a high court exercising ordinary original civil jurisdiction. I'll repeat. The 1996, the Principal Act version of the definition of the term court is the principal civil code in a district and includes a high court exercising ordinary original civil jurisdiction. This is the simple definition what has been given, and it also adds some supplements, like it shouldn't be a court inferior to a court of a small causes. When we are in the metropolitan cities, there are multiple small causes court. It shouldn't be an inferior court to a chief small causes court. In that way, the definition was adopted in the Indian perspective in the Arbitration Act. Now, in 2015, they wanted to make a change. Why this change? Before going into the change, what is the reason behind it? The reason was very simple. There was a very famous case called Bhatia International versus bulk trading, wherein a Ukrainian party had an arbitration conducted in India, and ultimately, when it comes to approaching the courts for multiple purposes, like interim measures, court assistance in taking evidence, the appeals and interim relief, that is the Section 37 applications, all these were literally also taken to the principal civil court in the district until and unless that particular jurisdiction doesn't has a high court which is exercising ordinary original civil jurisdiction. This is very simple. No need to just get complicated. In India, during the British period, we had a lot of trial courts. Madras, Bombay, Calcutta, Delhi, and to some extent Shimla, because of the British administrators were using Shimla to be the like a summer capital. In these cities, the courts were functioning as a trial court, and later, after the independence, all these courts were upgraded to high courts, and still they have been given a additional leverage of chartered high courts. And these chartered high courts has the option of having original side civil jurisdiction. That means those chartered high courts can also act as a trial court. That means even a simple issue based on the pecuniary value, sometimes the High Court might be quite engaged with a lot of administrative activities and appellate and writ jurisdictions. All these might put a lot of pressure to the High Court judges. In that way, a pecuniary value of less than 5 crores would be shared with the district courts. In that way, a pecuniary value has been bifurcated, but general principle is that the principal civil court in a district and includes the high court exercising ordinary original civil jurisdiction. Getting back to the reason for it. In that particular case, in the international case, unfortunately, the foreign party had to approach the principal district court, and that court was not in a actual position to give an effective relief, and ultimately it went on for a long time in the district court, and then it came for the high courts and then to the Supreme Court after a long period. This is really a trouble creator. That means we have a notion and we have a general perspective that India is growing to be a hub for international arbitration. India is obviously a hub, but still, when it comes to a successful hub, it needs to have a judiciary which is effectively dealing with such arbitrations. And for international arbitrations, if you give the jurisdiction to a principal district court, that doesn't mean that it is not competent. It is not incompetent to consider a district court to deal. But these matters, international matters, has to be dealt with the high courts depending upon the multiple aspects of enforcements and other aspect of judicial pronouncement, wherein these orders or these judgments given by the principal district court shouldn't be an obstacle for enforcement. That is the reason why the definition of the term court is amended in a particular section, that is section 2C. And if you look on that with the reasons, it is on multiple aspects. That is interim measures, as I earlier mentioned, the court assistance in taking evidence, an appeal to interim relief shall apply to international commercial arbitration, even if the place is outside India, subject to an agreement to the contrary. Now, the amendment, what has been suggested and what has been implemented is that if your arbitration is an international commercial arbitration, then the definition of court is being amended in such a way that those matters can be dealt only by the high court. And the definition court refers to only high court and not principal civil court in a district. In that way, now we have a relief that if that arbitration is an international commercial arbitration, that means one of the party might be might be a foreign national, might be a foreign government, might be a company incorporated outside our country, or even the parent management of that company might be outside our country. All these are some criteria to consider the nature of that arbitration. Now, international commercial arbitration with these 4 criteria can go to the high court when it comes to seeking interim relief, as well as taking court's assistance in taking evidence, and for multiple purpose. We need not go to the principal civil court. After 2015, the major amendment, we can go to the high court for international commercial arbitration, and for domestic arbitration, still it stands good, the principal civil court, including a high court exercising ordinary original civil jurisdiction. This is a great paradigm shift, wherein India, we have only one law. Very important thing. There are some countries like Singapore. I think many would be aware of international arbitrations. The best venue is Singapore. Another best venue is London. Then Paris, then Stockholm. There are multiple jurisdictions. Why? These jurisdictions are developing because some of these jurisdictions have 2 laws. One dealing with domestic arbitration and another dealing with international arbitration. That way, they have affected this particular process in 2 different legislations so that there is no overlapping. But India, like even developed jurisdictions like Hong Kong, we do have only one law which is dealing both domestic and international. Nothing wrong in it. But now we have the distinguishing factor wherein the High Court now has the jurisdiction to deal with the authority of the term court when it comes to international commercial arbitration. Moving on to the other amendments. whatever important I just brought in here, I have not brought in the entire set of amendments, but very important amendments I just brought in. Electronic agreement and interim measures by the court. Electronic agreement. Normally, we are in the digitalized world. A lot of changes are happening. There are a lot of challenge also how to deal with these electronic agreements. Whenever we are going to purchase anything online, nowadays is just look into a box, put a tick and agree and move. All these electronic agreements are rapidly developing, and now there is no opportunity for us to even see an agreement in paper and read it and then sign it. Now all is being digitalized. Most of the contract. With the development of technology and cross-border agreements, arbitration agreement also should go with these development, particularly the electronic form came into existence. Now, an arbitration agreement also is possible to be in electronic form, and to recognize such an electronic agreement, the original Principal Act, Section 7, which is dealing about arbitration agreement, now mentions that an arbitration agreement contained in the form of electronic means shall also be treated as an arbitration agreement in writing. The Principal Act is very particular that an arbitration agreement shall be in writing. To confirm that and not to just dilute from the basic principle of mandatory conditions of written arbitration clause, now the recent amendment has facilitated even an electronic means to be a valid arbitration agreement, that too at par with an arbitration agreement in writing. That way, you need not worry. The 2015 amendment also facilitates an electronic mode of the arbitration agreement to be considered as an agreement in writing. Now, we need not worry about whatever agreement you are signing, the online platform and the electronic world or the digitalized platform, whatever you are signing. Now, if that form or the contract also possess an arbitration agreement, that arbitration agreement is also considered to be a valid arbitration agreement. That valid arbitration agreement can at any point of time be invoked by the parties. That means the impediment of commencing the arbitration has been removed. Whether it is a normal contract or whether it is an electronic contract, we can arbitrate. That has been another change which the 2015 amendment has brought in. Moving on to the first aspect of the role of courts in arbitration. Many of you would have seen when we are dealing with, along with a legal expert, particularly in an arbitration case, before commencement of the arbitration, we will try to go to the courts. It is not that unnecessarily we are just knocking the doors of the court. Until an arbitral tribunal is constituted or the arbitrators are appointed, we need to safeguard. And as a conservatory measures or as a precautionary measures or as an interim measures of protection, very well, either of the parties can go to the courts. That is a basic understanding of Section 9. Where an order for any interim measures passed under this subsection of Section 9 before the commencement of the proceeding, the arbitral proceeding shall commence within a period of 90 days from the date of such order. There is no correlation. I'll try to explain why we are just bringing in this time frame and why the amendment has suggested this time frame. In most of the arbitration, before appointment of an arbitrator, if they approach the court and get a Section 9 relief, that is interim measures of protection, if it has been sought and the court also grants, most of the parties simply enjoy that order and they won't commence that arbitration. they won't appoint the arbitrator. They literally just prolong the matter even for a year, and literally the arbitrators won't be appointed. And with that Section 9 order, the party would be enjoying, and the other party would be in a situation because he can't just invoke because the invoking party has approached the court and got some interim measures. This was a gray area in the 1996 Principal Act. And most of the, more than 50% of the cases, they will delay the commencement of the actual arbitration. Now, they want to give a limitation for it. And now the amended version, 2015 amendment version of Section 9 is that once an order for any interim measure is passed under this section, the arbitral proceeding shall be commenced within a period of 90 days from the date of such order. Now it is clear the parties can enjoy that particular interim order for only 90 days. And if they are not commencing, then that particular interim order gets lapsed. And further, if you see, once the arbitral tribunal is constituted, the court shall not entertain an application for interim measures unless it finds circumstance that may render the remedy provided under Section 17 inefficacious. In an arbitration, we have an arbitration agreement. We have that agreement, whether in a physical mode or electronic mode, but still, before commencement of an arbitration, we are getting interim measures from the court. And here we are going to start the arbitration. To start the arbitration, the amendment has facilitated 90 days. Not only that, once the tribunal is constituted or appointed, that is, the arbitrators are appointed, then the court shall not entertain, very important. This is a major change from the 1996 Principal Act. It is not that the court can keep on granting interim measures until the completion of the arbitration. Once the arbitration tribunal is constituted, that is, the arbitrators are appointed, then the court shall not entertain an application for interim measures. Exception is that if the tribunal, the arbitrator is not in a position to grant an efficacious order, then we can go to the courts with some exception. It's very limited, but the clear mandate now given to the interim measures provision is that get the interim measure, commence the arbitration, and once it's commenced, approach the arbitral tribunal to get interim measures, not the court, so that we can effectively continue the arbitration and complete the arbitration within a reasonable time. Along with Section 9, interim measures by the court, another interesting amendment also happened in the interim measures by the arbitral tribunal, that is Section 17. Section 17, which was a toothless provision, while reading the 1996 principal version of that particular provision, it is very simple. Very limited power is given to the arbitral tribunal to grant interim measures. But in 2015, since the change which has been suggested in Section 9, wherein the second part of Section 9, which speaks about the court shall not entertain an application for interim measures after the tribunal is constituted, then now a reasonable level of power also is given to the arbitral tribunal when it comes to granting of interim measures. Section 17, which was considered to be toothless, now has been expanded, and it is a simple reproduction of the original Section 9. The same words and the same powers and the same authority is now being indulged or given to the arbitral tribunal also. Now, the arbitrators or the arbitral tribunal shall have power to grant all kinds of interim measures which the court is empowered to grant under Section 9. Literally, the provisions in Section 9 has been adopted now in 17 also. And when you look on such interim measures, it can be granted by the tribunal during the proceedings or at any time after making the award, but before it is enforced under Section 36 of the Act. The period is stretched. They have abundant authority now to grant interim measures. And further, any order issued by this arbitral tribunal or the arbitrators shall be deemed to be an order of the court. It is not for specific purpose, it is for multiple purpose, for all purpose, and shall be enforceable under the Code of Civil Procedure in the same manner as if it were an order of the court. The great change. First, whatever powers given under Section 9 is now given to Section 17. Secondly, that power has a certain extended period even after making the arbitral award, but before enforcement of that award. And finally, to give an effective enforcement regime for that interim orders given by the arbitrators. The provision, Section 17, has been amended and an inclusion of the word specifically any order issued by the tribunal or the arbitrators for grant of interim measures shall be deemed to be an order of the court for all purpose and shall be enforceable under the CPC, the same manner as if it were an order of the court. Now, the difference between Section 9 and Section 17 order is now narrowed, and whatever orders given under 9 or 17 is all considered to be an order given by the courts. We now need not go to the courts once the arbitrators are appointed, get an interim relief within a reasonable time, and then proceed to the arbitration. And until the arbitration is completed, that interim measures which stands good, sometimes even after making the award, until it is taken for enforcement. In that way, we can preserve the subject issue in hand. Whatever might be, if you look on Section 9 and 17, the amended version, particularly 17, it is even including one particular subsection stating that a tribunal can grant an interim order which he or she finds to be just and convenience. So much of power is given to the arbitral tribunal similar to the courts. Whatever just and convenience they can grant, and once it is granted, that also has the same status and scope of an order given by the courts. That means they can effectively enforce such an order. And when you look on all these changes which happened in Section 17, now Section 17 is considered to be a toothful provision. The toothless provision has now changed into toothful provision, and now we need not disturb the courts. The judicial courts are there only before appointment of an arbitrator to deal with interim measures or grant interim measures or even refuse granting interim measures. But once the arbitral tribunal are appointed, we need not go to the courts until and unless if you find that the tribunal is not in a position to grant efficacious order. That rarely occurs, but in most of the cases, literally now we are having a constructive enforcement of interim measures, that two interim measures granted by the arbitral tribunal. See the way how the amendment has addressed the anomalies what we are facing in the original act. The 1996 Act, even though it is considered to be an excellent act, had certain issues, and all those issues from 2015 has been well taken care, and now we have these reasonable amendments which has made arbitration to be still an effective alternative dispute resolution mechanism happening outside the courts. Okay. Moving on to another aspect of what we are facing, the problems when it comes to appointment of arbitrator. All know that Section 11 deals with appointment of arbitrator. And it also says any person of any nationality can be appointed as an arbitrator. But still, when it comes to disagreement between the parties, in most of the cases, they won't agree, and ultimately they have to approach the High Court under Section 11 to seek the appointment. It is not the Principal Civil Code, which is the general definition. Normally, Section 11 in the Principal 1996 Act itself suggests the parties to approach the High Courts. Here also, parties were facing a lot of issue, particularly when it comes to international commercial arbitration. And the 1996 also suggests specifically that the Chief Justice of India or the Chief Justice of the respective High Courts shall appoint the arbitrator. Because of this provision, most of the arbitrations or 100% of the arbitration appointment petitions go to only the Chief Justice, and the Chief Justice, in addition to his regular administrative work, he has to deal with this appointment, and they can literally spend 1 or 2 hours in a week to just make the appointments. There were gray issues because of this, and in some high courts, some of the Chief Justices were in a situation that they couldn't appoint the arbitrator even within a year, or sometimes the appointment applications were pending for more than 4 to 5 years. It is not their fault, but still they were overloaded with all these applications, multiple applications, and they couldn't focus constructively to make the appointment of the arbitrator under Section 11. Even though there was a authority to delegate to any other person or an arbitration institution, no courts were taking the chance to delegate. Why? Because there were several judgments stating that the role of Section 11 applications dealt by the high courts is a judicial role, and if it is a judicial role, it cannot be delegated. If it is an administrative role, it can be delegated. But the later stage, there were multiple judgments which confirmed that the role of High Court Chief Justice or the Chief Justice of India or the Supreme Court is an administrative role. Their duty is to just look into whether there exists an arbitration agreement and appoint the arbitrator. In that way, once it is confirmed that it is an administrative order, then this authority can be delegated. Now, it can be delegated. That's what the judgment, many judgments highlighted. To confirm this, Section 11 in 2015 saw the amendment. What the amendments mentioned? Appointment of an arbitrator shall now be made by the Supreme Court or the High Court, as the case may be, instead of Chief Justice of India or the Chief Justice of the High Court. That presumes any judge of the Supreme Court for international commercial arbitration and any judge of the High Court for domestic arbitration. We can now file an application in the registry of the High Court, and those applications would be placed before any judge of the High Court, so that the appointment would be made in the earlier stage. Not only that, in the same provision, they have also included some time frame, which is 60 days, which is not mentioned here, but a time frame for the judges to make a reasonable endeavor to make the appointment within that time. Now, appointment of an arbitrator by the High Court or the Supreme Court is reasonably done, not only in time, and also the scrutiny is reasonable, and the arbitrators are appointed and the arbitration process are effectively conducted. Here, one more aspect also was added. It is actually section 11 capital A, wherein the High Court, even though they are empowered to frame rules for the purpose of determination of fees of the arbitrators and manner of such payment, the High Court, while framing the rules, shall take into account the rate of fees specified in 4th schedule. It is not a mandatory fee, which has been suggested or recommended in 2015 amendment. It is just a rate card given in 4th schedule, which is inclusion in 2015, wherein the High Court, the respective High Court, can frame rules and fix a rate of fees. This is the reason why many of the High Courts have also fixed fees based on the 4th schedule. Even in most of the cases, it is not followed. Why? Because when you look on these 4th schedule title itself, it shows that it's a model fee, and it is not mentioned as a mandatory fee. In that sense, people are not seriously taking into consideration of it, and the arbitrators also has the discretion to fix the fees even beyond the 4th schedule. But a reasonable development in section 11 reference to inclusion of a 4th schedule is that the court, High Court, has an authority to frame rules taking into account of the rate of fees which is being specified in 4th schedule. In that way, now the arbiter tribunal can also be reasonably cost. It won't be too expensive. A reasonable cost can be levied, and the arbitrator's fees would be reasonable, taking into consideration of the 4th schedule. This section 11 changes, which now limited the time. Many of the arbitrations, particularly involving public sector undertakings, goes to the court for section 11 application and just kept pending for years together. Now that is changed. Appointment is reasonably made within 3 months or 4 months from the date of the request, and there is a law provision also which facilitates that a reasonable time of 60 days can be taken for the courts to appoint. 60 hours can be even extended, but it's just an endeavor what they can do. Most interestingly, when it comes to fees of the arbitrators, a rate card can be suggested, or the High Court can frame rules. Based on that, the arbitral tribunal can levy the fees on the parties for a particular range of disputes. If you look on 4th schedule, it is literally sharing with us some rate cards. And if you can look into, I'll just try to share this particular rate card. Just bear with me. I'll take that particular schedule. This is a good change, but unfortunately, many of the high courts have yet to frame rules on it. Hope in coming months or years, we will have this schedule, a model fee, which is suggested as a model fee to be taken into consideration. Okay, I got it. I'll just share it. Hope it's visible to all. This is the 4th schedule. What has been suggested, or what the amended version of the and 1996 Act in 2015 shows. The fourth schedule, if you see the sum in dispute, they are given like income tax slab up to 5 lakhs, 5 lakhs to 20 lakhs, 20 lakhs to 1 crore, 1 crore to 10 crores. It has to be 1 crore. It is a typo error. Later they have just changed that also. Then above 20 crores. And if you look on in the right column, it is suggested only model fee. Minimum of 45,000 and maximum, if you look on the last one, with a ceiling of rupees 30 lakhs. This is a model fee, what has been recommended in 2015 amendment. And in the event, if you look on the last point, the note at the bottom, in the event, the arbitral tribunal is the sole arbitrator, that is, the arbitral tribunal is consisting only of 1 instead of 3, he shall be entitled to an additional amount of 25% of the fee payable as per the table set out above. That presumes that whatever has been mentioned above, it is for 3-member tribunal. And if it is going to be an arbitral tribunal with 1 arbitrator, then that arbitrator can add 45,000 plus 25%, and that he is entitled as a model fee. This is greatest development what the law has recommended, and now there are multiple court cases which has taken up this very seriously, whether the 4th schedule has to be followed or it is just a model fee, whether it can make it as a mandatory fee or how the fees can be structured. I think the Supreme Court coming months would come out with a particular judgment in the ONGC case. They have consolidated multiple cases, and in that case, they are working out what can be the best fee structure, and the court might come out with a fee structure or rules of for fee structure, and that can be the future. So that now whether we are going to take ad hoc arbitration or institutional arbitration, no need to worry. Institutional arbitration, we go for it because we have the upper cap. That is, we are not much worried about the escalation of cost because there is a limit on it. Similarly, in ad hoc arbitration also, we are going to have an upper cap. This upper cap is going to facilitate the arbitrations in India, whether domestic or international, in a very successful manner. Going back to the presentation. Now, the impediment has gone. We can appoint the arbitrators and we can get the possibility, or we can see the possibility of appointment of arbitrator within reasonable months. Similarly, we also can go with a specific structure of fees to a reasonable level in most of the arbitration. Okay. Moving on to another provision, section 25. I think many of you would have gone through section 25, which generally speaks about non-cooperation of the parties or default of the parties. Whether it is domestic arbitration or international arbitrations, in many cases, the parties doesn't turn up. Even in courts, it's happening. In the courts, after issuing the services or the summons, a party doesn't turn up, but the court has an authority wherein the court can constructively invoke the authority to make the party who is absent ex parte and take ex parte evidence and proceed in an ex parte manner. How we are going to deal in arbitration? In arbitration, what are the mechanisms we have to deal with non-cooperation of parties or non-participation of the parties? Generally, in the 1996 Principal Act, this section 25 deals with it. It is a very simple provision having 3 subsections. And the 3 subsection, 1 speaks about the party who is invoking, that is a claimant, the plaintiff, who starts the arbitration. A person who is starting the arbitration carries a responsibility to also file the claim statement, which is very much essential for that party to take that arbitration in a constructive manner. Without a claim statement or a claim petition, there is no arbitration. In that way, a caution is given for non-cooperating party, that is the perspective of claimant not filing. The claimant is not filing, then the arbitrator need not wait for longer time. He can simply terminate the proceedings and close it off. He might not receive his fees, but still there is no purpose. Without a mandate, he can continue. This is for the claimant. Nothing, there is no much change or a problem in it. There was a problem in most of the respondents' perspective. Here in section 25, the change what has been brought in is the right of the respondent to file the statement of defense has been forfeited if the respondent fails to communicate such statement in accordance with the timeline agreed by the parties or the arbitrators without reasonable cause. Now, the responsibility of the respondent as per the legislation is that once there is a statement of claim, if a statement of claim is filed, then it is the responsibility of the respondent, that is the other party, to file an objection. That is the statement of defense. If he is not filing, that too after a reasonable opportunity or a time frame is given, then the arbitrators or the arbitrary tribunal need not wait for that, need not give further opportunity, because in most of the cases this gets delayed. They will participate, the respondent will participate, but they won't file any papers. They won't file any statement of defense or objection or documents. Simply they'll just participate and just create something orally. They'll just make some submission that will be recorded, but still a proper statement of defense or an objection would not be filed in the arbitration proceeding. Now, in the 2015 amendment, section 25 has been slightly modified, wherein it is clearly mentioned that the right which is given to the respondent, the right given to the respondent to file his statement of defense is deemed to be forfeited if that respondent fails to communicate such statement in accordance with the timeline what the parties have agreed or the arbitral tribunal has fixed, even without reasonable cause. Here, this makes the parties to participate, whether they are constructively participating or not, but still this participation, that too making the party realize that what would be the consequence of not filing the statement of defense within the reasonable timeline agreed by them or suggested by the arbitral tribunal. They have to face that consequence. That means they have missed that opportunity to file the statement of defense, and the arbitral tribunal can proceed with whatever documents is being placed before them. It is similar to an ex parte one, and it is clearly mentioning that the right of respondent to file the statement of defense has been forfeited. He is voluntarily forfeiting this right to make the statement of defense. In that way, we can more constructively we can just make our case. And if you can see, there was some question raised. If a proper statement of defense is not filed by the respondent within a reasonable time, then can the arbitral tribunal go ahead and hear out the plaintiff and make an award? It is not that whether the statement of defense is a proper one or an improper statement. A document with a heading like a statement of defense or an objection is filed, that itself is sufficient for the arbitral tribunal to conduct that arbitration. It doesn't mean that it is a right which has been forfeited by the respondent. They have filed that document. The arbitral tribunal has to take into consideration and pass a speaking award. That is very important. But here, the beauty is that this amendment has facilitated an interesting point, that It is not that the respondent can literally enjoy the proceedings, not filing his statement of defense or objection. Now he has to file. If he is not filed within the time frame, then he is forfeiting his right to file it. Subsequently, he is not given opportunity to file the statement of defense. Okay. Adding on, in 2015, in addition to some major changes which has happened in the inclusion of fifth schedule, sixth schedule, and seventh schedule, which I'll share in that particular Word document. Insertion of new provision, which is 29 capital A. Most of the arbitration, what we are facing, as initially I was mentioning that sometimes some arbitration, a large, a complex arbitration goes for even more than a year or 4 years or 5 years. Now we have to make an end to that. To make an end to that, there was an inclusion which was section 29 capital A. What it speaks? The arbitral tribunal shall ensure speedy completion of arbitration proceedings and pass the award within the period of 12 months from the date when the arbitral tribunal enters upon the reference. Now, Indian arbitration law has seen a drastic change. In 1940 Act, we had a lot of time frames also. The same regime has been brought in 2015 only for passing the award. Here, the tribunal is asked to complete within a speedy manner the arbitration proceeding and also give the award within a period of 12 months, that is 1 year. That too from the date when the arbitral tribunal enters upon the reference. That is the actual appointment date. This 12 months has given great opportunity for even foreign parties to opt for Indian arbitration venues. If you're going to do an international arbitration in India, this provision also apply. This amended provision also apply. In that way, which is a very innovative inclusion in the 2015. No major jurisdiction has brought in such a provision of a time frame in an arbitration. In India, we have tried it. But this is not because of actually making India as a hub, but because of major criticism in international case, which is called the White Industries versus Coal India. In this case, the foreign courts have criticized our Indian courts to the maximum when it comes to conduct the arbitration, monitoring the arbitration, and even when it comes to enforcement or challenging the arbitration awards. Too much of delay is happening, and ultimately that outcome or particular outcome of that particular judgment has been taken into consideration, and now we have this 29 capital A, which is very clear that the arbitral tribunal shall pass the award within a period of 12 months. And another proviso to give some leverage to the arbitral tribunal, they have added. However, the parties may extend such period for a further period not exceeding 6 months. That means the arbitrator has been given 12 months. And that can be extended if both the litigating parties, that is the claimant and respondent, if both of them are agreeing, then it can be also extended to a maximum of 6 months. Now, 12 plus 6, 18 months. 12 is clear. 6 is discretion or with the consent, mutual consent of both the parties. That is possible. 12 plus 6, 18 months is a wonderful time frame. 1.5 years to complete the arbitration. And if that award is made within a period of 6 months, the arbitral tribunal shall be entitled to receive additional fees as the parties agree. It is an incentive also given in the law. It is not my inclusion. The amended version of the law also gives an incentive for the arbitral tribunal who completes within 6 months. This is not an exaggeration of this amendment, but this amendment has given 12 plus 6, 18 months. And further, there is a concept, if you can complete within a period of 6 months, they can be awarded. The arbitrator can be given incentive, an additional fee as the parties agree. But here, if the award is not made within this specified period or the extended period, specified is 12, extended is another 6, 18 months, the mandate of the arbitrator shall terminate unless the time is extended by the court. Here, they have given clarity that the arbitral tribunal cannot proceed beyond 18 months. The clear mandate is 12 months, but another 6 months, both the parties, obviously, they'll agree to have a conclusion. Beyond 18 months, the mandate of an arbitrator gets terminated. There is no chance for that arbitrator to continue. Even if he continue and give the award, that award can be easily set aside because it is against the public policy of this country. The law is very clear. The mandate of an arbitrator shall terminate unless the time is extended by the court. The court has power. The court can extend, but still it is very risky in most of the cases wherein the court won't give that opportunity to extend that arbitration proceeding unless there is a reasonable cause for seeking such extension. But 29 capital A has changed the regime, arbitration regime with a time frame 12 plus 6 beyond termination of the mandate of an arbitrator. Here, they have included one more provision which is called 29 capital B. In India, most of the states have a concept called fast track courts. Fast track courts are deemed to be courts which are very cumbersome in completing the the court proceedings within reasonable time. And there are specific time limits given for fast track courts. Similarly, 29 capital B was included in the 2015, which is not mentioned here, wherein two major theories apply. One, that arbitration shall be conducted based on documents only. It is not that oral hearings should be conducted. Just the parties can file the documents and the arbitral tribunal can look into the documents and pass the award. Further, in 29B, what they have added is that arbitration proceedings has to be completed within 6 months, with the condition that the tribunal should be consisting of only one arbitrator. Very innovative change what they have suggested. 29B, 3 things. 1, documents only hearings. 2, complete within 6 months. 3, specifically we can have only one arbitrator, and this would be good for small claims, less complex disputes, and a simple case which can be constructively or effectively completed within a reasonable time. This 29B, which is suggesting about the aspect of completing within a reasonable time, also gives the opportunity to the parties not divulging with oral hearings. Sometimes, traditionally, the oral hearings are fine, no doubt on it. But it is not very common to have oral hearings in all cases. Oral hearings are essential when there are serious allegations raised or objection raised by one of the parties pertaining to some documents or pleadings. Otherwise, if the tribunal feels that it is a straight case, it is always better to go along with the documents. And we can also opt for the fast track procedure, which has been suggested in the 2015 amendment of the Arbitration and Conciliation Act. And to add on some more provisions, like 34, which speaks about challenge of the arbitral award. Once an award is given, it is not a smooth ride. That is another one drawback what we have in arbitration. There is one opportunity for the unsuccessful party to take it for challenge, not appeal. It is considered to be a challenge or an application to set aside an arbitral award. The change what has been brought in the 2015 amendment is twofold under 34. One speaks about an application for setting aside of an award under this section is to be filed after issuing prior notice to the other party. Very important. Earlier, in before 2015 amendment, it was very simple. They'll just file it, and it becomes automatic stay of the enforcement of that award. The successful party has to literally wait for a longer period. Now, until the completion of that challenge. Now it is very clear the other successful party also has to be intimated. They will participate, and in most of the cases, such challenge would be entertained based on conditional order. Conditional order means sometimes if it is an award for money, and assuming that 1 crore is awarded in that arbitration, the courts under section 34 can entertain challenge by way of conditional order, levying some or asking the party who's approached the court to literally deposit 50% or 75% of what has been the award money to the courts, so that until the completion of that process, it has to be in the court's treasury, which doesn't carry interest also. In that way, the change, the amendment in 2015 limits the unsuccessful parties which normally finds that their challenge is just a procedural one. They won't make the challenge because of the huge cost involved. Huge conditional orders would be placed by the courts. In that way, this proposed amendment is minimizing the opportunity what has been given to the unsuccessful party to go before the court. It doesn't restrict that power, but still there is a high possibility of limited applications taken under section 34 to set aside the arbitral award. Additionally, 34 subsection 6 has been included, which says a period of 1 year has been prescribed for disposal of an application for setting aside an arbitral award. This is for the courts. When you happen to look on section 11, which is about the appointment of an arbitrator, they can make an endeavor to make an appointment within 60 days or 90 days. Similarly, when it comes to setting aside the arbitral award, a period of 1 year has been prescribed for disposal of application for setting aside. Normally, before 2015, what was happening is that even disposal of setting aside application even go for more than 5 years in most of the high courts. It was getting delayed. Too much of delay was happening, but still it was it was in practice. And now this amendment has asked the court to have an endeavor to complete within 1 year, try to dispose of such an application within 1 year, particularly the setting aside applications of the arbitral award. Before moving to 2019 amendment, there are some very major aspects which you have to look into the 2015 amendment. they have included three schedules, which I'll just try to share now. In India, we are trying the best adventure, and this is one major adventure what the Indian lawmakers has made in the arbitration law in 2015. In international arbitrations, we do have soft laws. Many would have already seen those soft laws, which is called the best practices. It is not mandatory laws. Those are just best practices which can be adopted. And those soft laws have framed multiple rules and regulations just for our guidance. One such rules is the IBA guidelines for conflict of interest for international commercial arbitrators. IBA guidelines on conflict of interest for international commercial arbitrators. This is a soft law which India has literally adopted in the law by way of including 5th schedule and 7th schedule. I'm just displaying this 5th schedule. See, point number 1, that to above the heading, arbitrators' relationship with the parties or counsel, then relationship of the arbitrator to the dispute, arbitrator's direct or indirect interest in the dispute, previous services for one of the parties or other involvement on the case, relationship between an arbitrator and another arbitrator or counsel, relationship between arbitrator and party and other involved in the arbitration, other circumstance. There are some 34 categories of relationship with the parties, so the arbitrators have to make a declaration. And this shouldn't be an opportunity for the parties to later make a challenge against the arbitrator because there is a conflict of interest. And if you look on, considering some questions also raised, the 34 applications are normally made to the principal civil court in the district, includes the High Court exercising ordinary original civil jurisdiction. And these applications are made only before the courts, not by the arbitrator. The award has to be passed, and the award can be passed only within the time, that is 12 months plus 6 months, 18 months. The 18 months has gone. Beyond that, if the arbitral tribunal pass an award, even with the consent of the party and not with the permission of the courts, then the court can literally reject those application. And if at all, the tribunal also considered that the tribunal has no authority because the mandate has gone. Now the court can straight away set aside because that mandate of the arbitrator has got terminated. Looking into this 34 categories with some explanation or like an exception, just I'll read the explanation alone. The term close family members refers to a spouse, sibling, child, parent, or life partner. Then 2, the term affiliate encompasses all companies in one group of companies, including the parent company. 3, for the removal of doubts, it is clarified that it may be practiced in certain specific kinds of arbitration, such as maritime or commodities arbitration, to draw arbitrators from a small specialized pool. If in such fields, it is the custom and practice for parties frequently to appoint the same arbitrator in different cases, this is a relevant fact to be taken into account while applying the rules set out above. 3 things. 1, close family members. wherever the term close family members is mentioned, and we are likely to be appointed as an arbitrator, when it comes to something to declare, depending upon these various categories, totally 34 categories, the close family members represent or refers spouse, siblings, children, parents, as well as life partner. Imagine we have to be very cautious while taking the arbitral appointment. And at the time of taking the arbitral appointment, we are making a declaration. Assuming that, I'll just take point number 1. Arbitrator's relationship with the parties or counsel. Now, if the arbitrator is an employee or consultant or advisor or has any other past or present business relationship with the party, then it is the responsibility of the arbitrator to declare it. This was the practice before 2015 in India, to even have the employee of one of the party to sit as an arbitrator. When you would accept, when you're dealing with the public sector undertaking or the military engineering services or the railways or the Navratna companies, literally they were appointing their own employee as their arbitrator or as a sole arbitrator. This was in practice from 1990s or even before till 2015. And in 2015, they have brought in these schedule, 5th schedule. And in 5th schedule, there are 34 items. And in these 34 items, the first 19 item, I'll just read the 19th one. The arbitrator or a close family member of the arbitrator has a close relationship with a third party who may be liable to recourse on the part of an unsuccessful party in the dispute. Who are the close family member? Refers to spouse, refers to sibling, refers to children, refers to parents, refers to life partner. Unimaginable. And not only that, that close family member has a close relationship with the third party, not even the disputing parties, who may be liable to recourse on the part of an unsuccessful party in a dispute. Somehow they are related to that dispute, even through a third party, then that also has to be declared. Unfortunately, when an arbitrator is taking an appointment and looking into this schedule, first of all, he has to make a declaration, and that declaration has to be in this format. Okay, I'll just take this format. This is 6th schedule they have added. Have a look on it. Now it is not so simple getting an appointment and easily continuing with the arbitration process. The arbitrator has to give a declaration based on this format. He has to declare his name. He has to mention his contact details. He has to mention about his prior experience, including arbitration experience. Most interestingly, number of ongoing arbitration. There are some arbitrators who will take 50 cases, 100 cases in a month, and they can't just focus and dedicate their time for the cases. In such a situation, they can't complete within the 12 months or even further extended 6 months, 18 months, and it might get, the mandate might get terminated. For that purpose, it is always better as a template, what has been suggested, that the arbitrator has to give a declaration number of ongoing arbitration, not the completed one. The completed one might be the earlier one, prior experience. And also circumstance disclosing any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind. Because the Pandora box is open, other kind, which is likely to give rise to justifiable doubts as to there is arbitrator's independence or impartiality. This is what declaration you are going to give based on the fifth schedule. Further, circumstances which are likely to affect your ability to devote sufficient time to the arbitration, and in particular, your ability to finish the entire arbitration within 12 months. This is quite a reference to 29 capital A, which speaks about 12 months. The same is being reproduced in this sixth schedule template. Along with his name, contact details, prior experience, number of ongoing, he is going to declare based on fifth schedule, and he's also giving circumstance. Sometimes some arbitrators, as a soft comment, would take the appointment and later they'll just go to US, spending their time with their kids for 6 months, 7 months. Now, due to pandemic, how we are doing this online, we can also do online, but still, some of the cases they wanted to do in physical mode. In such a situation, we need to complete that arbitration within the reasonable time. But if he is trying to go, he couldn't complete, and that also can be declared. This declaration is now mandate. It is compulsory to put this declaration. Earlier, it was not like that. It was just a best practice, that is the soft laws. Now, in our country, the 2015 amendment has brought in within the law. That means a mandatory provision is there for the arbitrator at the time of taking the appointment, whether appointed by the court or mutually by the parties or even by the institution. They have to give a declaration, and that declaration should express the ability, the ethical responsibility, and their expertise. And the most vulnerable thing comes the seventh schedule. Whatever given in fifth schedule, there are 34 items or categories, which is all repeated in the first 19 is being repeated in seventh schedule. You can see till 19. I'll read first the first point, which is same as fifth schedule. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship. Exact, the same categories. And if you look on the 19, the arbitrator or a close family member of the arbitrator has a close relationship with the third party who may be liable to recourse on the part of the unsuccessful party in the dispute. Here, the vulnerable situation is mentioned in section 12(5). When you're giving a declaration at the fifth schedule, there are 34 categories, and you're taking the template which is given in sixth schedule, you're declaring, and if your declaration comes within the 1 to 19, then seventh schedule is attracted. What is vulnerable under seventh schedule is all given in section 12, subsection 5, which is also a 2015 amendment, which intentionally I didn't mention earlier. Coming to the reference of this one, you can understand it. Sorry. Yeah. 12(5). Twelve is now a big provision, grounds for challenge. Coming down to 5, subsection 5, which is an inclusion in 2015. That is the reason it is marked separately. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in seventh schedule shall be ineligible to be appointed as an arbitrator, provided that parties may, subsequent to disputes having arisen between them, waive the applicability of the subsection by an express agreement in writing. Exception. It doesn't happen. But if an arbitrator at the time of appointment is giving a declaration, and while declaring, particularly the relationship category, 34 categories with the parties or the counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule, that is 1 to 19 of 34, is a replica given in 7th schedule, shall be ineligible to be appointed as an arbitrator. They are prohibited to act as an arbitrator. Immediately, they have to relinquish their prospective appointment. They can't continue as an arbitrator because they come under the relationship which has been declared and listed within 7th schedule. This is a interesting development. Anyway, many of the arbitrators would have a lot of conflict of interest when you look on the schedules. Multiple relationships are being declared, but still, it is good for many of the arbitration, particularly the large arbitration happening in our country. See what is given in 7th schedule. An employee, if he sits as an arbitrator, he is a master-servant relationship. One party is a master and the arbitrator is a servant. How we can expect that servant to go against the master? He might favor the master, and such appointment shouldn't be permitted. Look into 2. The arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. Sister concern. An arbitrator, most of the cases normally before 2015 or 19, many were lawyers. They might represent or advise one of the parties or affiliates. That also is vulnerable. If they sit as an arbitrator, it is direct fiduciary or financial relationship. Look on 4. The arbitrator is a lawyer of the same law firm which is representing one of the parties. He might be dealing with a different department of the law firm, but still he comes from the same law firm. If he sits, he might favor that particular lawyer from that law firm, and it will be biased or beneficial to that particular party. If you look on all these 19, invariably, these are the best practices which should be seriously considered, and they should not be allowed. A person in such relationship should not be allowed to sit as an arbitrator. Look into 16. What does it say? The arbitrator has previous involvement in the case. An arbitrator can change as a counsel, but earlier a counsel cannot change as an arbitrator. Simple theory. An arbitrator having previous involvement in the case, obviously he might be a advisor to that party, or he might have prepared an expert report, whatever might be. He would have facilitated one of the parties as he was involved in that case. If that person has been suggested or nominated, and if he gives a declaration, or if the parties could find that, then we can make that arbitrator ineligible to continue. These are some interesting points what the 7th schedule has suggested. And if you look on a very simple outcome, what you can see is about 17. The arbitrator holds, have a good reading on it. The arbitrator holds shares either directly or indirectly in one of the parties or an affiliate of one of the parties that is privately held. Most of the people, particularly after the pandemic, have entered into the online platform and doing a lot of trades, purchasing shares in a personal capacity, not on the official capacity. But when a person is going to take the role of an arbitrator, it is his responsibility, whether the relationship is direct or indirect, if he holds shares. That also they mentioned either directly or indirectly through some mechanisms like authorized representative. Many are there in the capital markets and commodity market. in one of the parties or an affiliate of one of the parties. Not only that party company, it is also the affiliate of that party company, which in the explanation they are given encompasses all companies in one group of companies, including the parent company. Imagine he is having it in his personal capacity. It is privately held. But whether it is direct or indirect, as an arbitrator whose position is considered to be unique, which position has to be beyond doubts, which position has to be with neutrality, honesty, as well as unbiased nature, that arbitrator alone would be in a better position to constructively complete this process and deliver the award within the reasonable time of 12 plus 6, 18 months. And if you continue with an arbitrator who comes under all these categories, these 19 categories given in 7th schedule, subsequently, there might be a high possibility of biased seen, and it can also be challenged unless and until both the parties agree mutually that we are in writing, we are agreeing that we are comfortable with this arbitrator, even though he has put such a declaration. But very few parties would take the chance. Most of the parties would straight away challenge or straight away request that arbitrator to immediately relinquish his position. He won't continue. But these developments, what has been suggested in 2015 are wonderful recommendations, which we have to appreciate. Why? Because as earlier, when the introductory speech was there, these amendments are now reasonably answering all the ill effect what we had in the 1996 Act. Now we can complete the arbitration within reasonable time. The courts are there only to deal with the within a reasonable time, granting interim measures and looking into the ill effect of the award. And the court also has been given some time frame to complete the arbitration. All these have been given, even post-award, they can also be tested in a reasonable time, as well as giving opportunity to the other parties. Okay, these 2015 amendment were also insufficient. And in 2019, there was another set of amendment which also created some issues particularly by including 8th schedule, which was good for many other professionals, but now it has been removed so that anyone can be an arbitrator. I'll touch upon that. This 2019 amendment was passed in month of August 2019, and major development in the 2019 amendment was in India, they wanted to regulate the arbitration. They wanted to not only regulate the arbitration proceedings, they also wanted to accredit or grade arbitrators. These two are the major ideas, and for that, a new council has been proposed in the 2019 amendment, which is called a creation of Arbitration Council of India. Interestingly, even though the topic is not for today, many would know that there is a mediation bill 2021 pending. In that also, they have suggested Mediation Council of India. This is the first step, Arbitration Council of India, but unfortunately, it is yet to be looking at structure. We are just waiting for when it is going to happen. But this particular council, which has been proposed, is similar to a professional regulator, like I think chartered accountants, you have this institute, company secretary, we have the institute, the lawyers, we have the Bar Council of India. Similarly, this Arbitration Council of India is going to create a new set of professional, which is going to be called arbitrator. Now, we are going to have a new profession, arbitration. we can also arbitrate. Once this Arbitration Council of India comes with a proper structure, it will also going to grade arbitrators. Thereby, we are going to get multiple chances of being appointed as an arbitrator once this council grade us and accredit us. This particular amendment wanted to establish an independent body, which is called this ACI, for the promotion of arbitration, mediation, conciliation, and other ADR mechanism. Entire, they wanted to bring in all, but for mediation, they have suggested we'll wait and see how far it's going to be separated from this ACI. Its primary functions would be framing policies for grading arbitration institutions. There are multiple arbitration institutions. I think CA Institute also has an arbitration cell. But all these institutions, like the traditional arbitration centers, they are functioning. But now this ACI would come out with a policy, and that policy would make ultimately that ACI to grade arbitration institution. Not only that, accredit arbitrators. They'll bring some standards, some experience in arbitration. And we had to wait and see what is going to happen. But as of now, we don't have. But these are the major functions: framing policy for grading arbitration institution and accrediting arbitrators. Further, making policy for establishment, operation, and maintenance of uniform professional standards for all alternative dispute redressal matters. They wanted to bring in a common pool all these ADR mechanism and give a value for it, give a tooth for it, and ultimately it will be a very constructive role what the ACI is going to do, and also maintain a depository of arbitral awards. That is the arbitration judgments, what has been given by the arbitrators. As of now, it's been the custody of those arbitrators. Ad hoc. Institutional, at least those institutions would maintain those awards. Now, it can be deposited in the depository, which is going to be created by this ACI. What might be the composition of the ACI? It's not much of significance, but still I'll just quickly read over. The ACI will consist of a chairperson who's either again judiciary, a judge of the Supreme Court, or a judge of High Court, or a Chief Justice of a High Court, or the ex officio members of ACI would include, now it's the government, first judiciary, now the government, secretary to the Government of India and the Department of Legal Affairs, Ministry of Law and Justice, secretary to the Government of India, the Department of Expenditure, Ministry of Finance, or their respective representative. Further, eminent person with expert knowledge in conducting of the arbitration, that is arbitration practitioners and experts. And other members will include an eminent arbitration practitioners, academicians with experience in arbitration, as well as government appointees. Anyway, when we are going to have a regulator, obviously the government would have a say. Since this career is going to be related to judiciary, judiciary also is going to have a say. But still, it is a reasonable development which we have to take in a positive note, wherein we can effectively take this forward and we can take a new career as an arbitrator or even run an arbitration institution. Moving on to other aspects of which is somewhat related to ACI and in the 2019 amendment, and one not pleasing amendment also I wanted to share that in a subsequent slide it is there. Under the 1996 Act, that is original Act, Principal Act, the parties were free to appoint arbitrators. Fine. In the case of disagreement in appointment, the parties could request the Supreme Court or the concerned High Court or any person designated to appoint an arbitrator. This was a normal thing. And in 2015, this power is given to normally to the any judge of the High Court or any judge of the Supreme Court. Now, under this section, the Supreme Court and the High Courts may now designate arbitration institution which parties can approach for appointment of an arbitrator. This is a very innovative idea, wherein if there is a section 11 application made by one of the parties, that is, they are seeking appointment of the arbitrator, they are filing a application under section 11. It is not that always the High Court in domestic arbitration and the Supreme Court in international commercial arbitration to appoint. Now they can delegate or designate arbitration institution, which is being all graded by ACI. ACI might grade multiple arbitration institutions in every states. Now these states or these institutions would be the right institution wherein this power would be delegated. Now even the 60 days time is not required for the appointment, or 90 days time is required. Now they can make an appointment in the institution within 7 days or 10 days. So much of effective appointment can be done by the institutions which has been graded by the ACI. That way, they are even saving some time. Similarly, in an international commercial arbitration, appointments will be made by institution designated by the Supreme Court. For domestic, it is designated by the High Court. All these is really a wonderful opportunity what has been given for all arbitration institutions to be getting the grading from the ACI. And once the grading is there, we can literally we can complete the arbitration within the reasonable time, and we can even considering the appointment, it will be smooth. If you look on, I'm just getting deviated. If you look on some questions, what has been raised. In the contract, which normally says that no written agreement is necessary, even oral terms of enforcement in law can be eligible. Can arbitration agreement be written and the parties clearly mentioned in such agreement to give notice by the arbitrator to parties invoking such contract? Legal counsels appointed, ignored by breaching party. Okay. The contract is oral, but the arbitration agreement is in writing. Whether it is possible? Yes. And for that purpose, if you look on section 16(1)(6), it clearly says that the doctrine of severability is applicable when it comes to invoking the arbitration clause. The arbitration clause might be a part of that contract, but still it can be severed. It survives even the contract or agreement is being eroded or terminated, or it is not in existence as of today. To just determine whether that contract is valid or invalid, void or voidable, or terminated, or still continuing, whatever might be the entire questions can be answered only by invoking the arbitration agreement. This is what, at least in my practical experience, I have just seen. Okay, coming to this point of appointment of an arbitrator, the delegation power given to the courts. Now the courts, High Court or the Supreme Court need not appoint. Once the ACI is created, the whatever graded institution, they can simply send the file. That's all. The registry can send the file, and that institution can appoint. Assuming that there is no arbitration institution available in that particular jurisdiction, which is not graded by ACI, the Chief Justice of the concerned High Court may maintain a panel of arbitrators to perform the functions of the arbitration institution. And very importantly, an application for appointment of an arbitrator is required to be disposed of within 30 days. Very interesting. If you have a power to delegate. If you have the institution, delegate it. They'll make it within 10 days. If there is no institution, then you need not worry. Let the court, or particularly the Chief Justice of the respective High Court, normally maintains panel of arbitrators if there is no arbitration institution. From that panel, they'll choose and recommend the names, and that has to be disposed of within 30 days. See how rapid the arbitration process, particularly appointment. Appointment is very important. the appointment is made within a reasonable time, the arbitration can also successfully complete and also be enforced. Okay. Moving on to other changes, what has been evolved in 2019 based on 2015 changes. They have included one time frame in section 23, which speaks about filing the statement of claim and defense. What they have included is that the addition of section 23(4) has made it mandatory for parties to an arbitration to complete their pleadings within a period of 6 months from the date of arbitrator receiving notice in writing of the appointment. This is a change from what 29A of 2015 amendment. A new time frame has been brought in. Instead of 12 months from the date of reference, entering reference by the arbitrator to pass an award and further 6 months, now they have 3 categories of time. One, we are not sure to what extent it is going to work out or it is feasible or viable, but still they have explored that within a period of 6 months from the date of arbitrator receiving notice in writing of the appointment, that is the appointment date or 1 or 3 until the third one is appointed, the pleadings have to be completed. That is all exchange of documents, pleadings like statement of claim, statement of defense, rejoinder, whatever. And then 29A has been amended stating that upon completion of pleadings, that is 6 months, the arbitral tribunal must pass an award within a period of 12 months in matters other than international commercial arbitration. Now, in 2015, this time frame was common for domestic and international, and in 2019, they are removing international commercial arbitration, no time frame, only for domestic, and that too, first 6 months for exchange of pleadings, then 12 months to pass an award. And the interesting fact is that further extension of 6 months with the consent of the parties has not been removed. Hope you can follow. Originally, in 2015, 12 months to pass an award from the date of entering reference plus 6 months the consent of the parties was there, 12 plus 6. Now, the pleadings have to be completed within 6 months from the date of appointment, receiving the appointment letter by the arbitral tribunal, then 12 months, 6 plus 12, 18 already given, and further extension with the consent of the parties still stands good. That means 6, 12, 6, 18 months are there. And after that only the mandate of the arbitrator gets terminated if he couldn't complete passing the award unless and until the court grants permission. Here, it is very important that we need to consider the aspect of how parties require arbitrator to assemble, give directions, conduct pleadings, and to disclose or not to disclose and another procedural wrangling with possible appeals to be filed. Obviously, an arbitration to be completed within a period of total of 18 months is impossible in many cases. This is my personal view. But still, in 2015 also suggested, now at least we have 12 plus 6 plus 6. Still, that 6 also is there in existence. It's not been removed in 2019. 18 months is quite reasonable for a mid-level arbitration with less complex nature in it. Most importantly, the final aspect in 2019, what the amendment has put forward is that we are saying arbitration is confidential, private, but still we can see in press some arbitration going there. Arbitrator gave an award of so-and-so in the arbitration proceedings. They are going for settlement. Such type of press releases we can come across. To stop those and to establish the very nature of arbitration to be private and confidential, a provision 42 capital A was included wherein the arbitrator, the arbitration institution, and parties to the arbitration agreement shall have to maintain the confidentiality of all the arbitration proceedings. Very important. Commencement till award. All the arbitration proceeding except its award, where its disclosure is necessary for implementation as well as enforcement or sometimes challenge. When it comes to the court for challenge or enforcement, it becomes a public document. But till that time, that award or the arbitration proceeding has to be kept confidential. That has been assured by inclusion of this particular provision 42 capital A. Okay, the 8th schedule, what I just missed, anyway, I'll just highlight here. This 2021 amendment, it was a small amendment. It is just adding some points like the second point, what has been mentioned. The unconditional stay on arbitration awards in case where the arbitral agreement or contract induced by fraud. The aspect of conditional order has been diluted in 2021. It's not a good sign, but still we had to wait and see to what extent is going to be changing the case laws. And other interesting points like amendment to section 36, which is speaking about enabling automatic stay on awards in certain cases where the court has prima facie evidence that the contract on which award is based was affected by fraud and corruption. These are some minor changes, but most important change, what has been brought in 2021 is there is a second amendment done to section 43J, which was added by 2019 amendment, which stated qualification, eligibility, and norms for accreditation of arbitrators. That has been removed. In 2019, under the ACI, they also suggested some qualifications, eligibility, and norms. That has been removed. And initial provisions inserted in 2019, which prescribe the experience, qualification, and accreditation of arbitrators to be specified under Schedule 8, now has to be substituted with the rules as specified by the regulations, and now it has been removed. 8th schedule, which prescribes 10 years experience for so-and-so lawyer, chartered accountant, company secretary, engineer, any officials, the private sector or the public sector, all has been removed. Now we don't have the 8th schedule, which was included. That is the reason why in the amended act you can't see the 8th schedule. It has been removed. Now, as per section 11, anyone of any nationality can be appointed as an arbitrator. That provision stands good until and unless, looking into the last point, the qualification, experience, and norms for accreditation of arbitrators, which is likely to be framed by the ACI, comes, anyone can be appointed as an arbitrator, and effectively we can complete the arbitration within a reasonable time, reasonable cost. And this omission of 8th schedule might also turn futile, but we have to wait and see to what extent these changes, which has happened in 2015-19, facilitate and answer all the ill effects, what has happened in the arbitrations which were conducted based on 1940 Act as well as the 1996 Act. Thank you. Thank you for patiently hearing me for more than 1 hour 45 minutes. Reasonably, I have just conveyed, sorry, my throat was not so good to convey the message in a clear manner, but I have shared some valuable points and some of the interesting amendments, what has been suggested in the amendment. And one more question, what I have to answer is that, could you please explain what a speaking order? It is speaking order in an arbitration is nothing but an order with reasons. Normally, before 1996, even an award can be given without reasons. That was permitted. Now, the situation has changed. Speaking award or an order is considered to be a reason award or an order. Just with reasons, legal reasoning or factual reasoning, or whatever conclusion you are going to come, that has to be a constructive conclusion with reasons. That is all about speaking order.
Thank you so much, sir. There are 2 questions, sir. If at all if possible, you can see it in chat box.
I think already I covered the first
It's
2.
covered, right, sir? So
I
then,
covered. Third also I covered. 4th, totally 4.
thank you so much, sir. Thank you so much for taking your time from busy schedule, and also, in spite of not being well, you've been here for others members virtually, and for nearly 2 hours. Thank you so much for your excellent session, sir. And we look forward to have you in future for a physical session.
Sure.
So, thank
Sure.
you, sir.
Thank you. Thanks
Thank
to all.